Lawyers, what's the worst case of, you should have mentioned this sooner, you've experienced? My first ever hearing in front of a judge as an attorney was a Social Security disability appeal. My client had been crushed at work a few years ago and his entire left side of his body was mangled. He had PTSD from seeing his dad shoot himself as a kid, loads of mental health issues and physical ones as well. Just my luck. I get the biggest dickhead judge the SSA has to offer. It's sort of an unspoken rule that you don't interrupt someone's opening statement. You don't make objections, you don't interrupt. Well, I get 3 sentences into my opening and I was listing his conditions and the judge screams over me, "You forgot one. What about the drug abuse disorder? When was the last time your client did heroin?" I froze for a half a second, glared at said client, and said, "Well, Your Honor, I didn't mention that, similar to how I didn't mention his prediabetes and seasonal allergies. It isn't relevant to his ability to work, as he hasn't abused drugs in several years. Additionally, he admitted that he used drugs to cope with his mental health disorders, which he has taken much better control over since he began counseling." I was damn proud of that response. My client won the case. I called to tell him. His GF answered and informed me he was in jail for the next 36 months for stealing a car. Story 2. A person involved in a motorcycle accident who sustained legitimate but not serious injuries. CCTV showed the incident. They were very much not at fault. They decided this was their big payday, claimed they could barely walk, had PTSD, serious back trouble, would never work again, the whole 9 yards. They neglected to tell their lawyer they had been working a manual labor job, riding motorcycles again, did a bungee jump, all of which we caught on video. They documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued for fraud. It was a fun phone call after we sent the tape full of evidence. Story 3. Special education case. Mother and school were fighting about services. We got new assessments that backed up the mother's claims. Local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route. Some extracurriculars kid was excited about. She goes to enroll him in school. Says they have a problem with paperwork. Thinking the transfer info just didn't get there yet. I take a copy and head down there. No, they won't enroll him because not his legal name. She is not his legal mom. Turns out she was the BFF of a mother who was pregnant and about to be incarcerated for drug trafficking. BFF says, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and husband say sure. They sign a piece of notebook paper. 12 years later. SMH, you have to think, how did they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They'd just been using an assumed last name of the pseudo-adoptive couple. And like me, no one had asked. It was only that the school had moved to an online system that checked SSHs against other databases that it was caught. Anyway, bio mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting. Kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Edit. Yes, it was the couple that had raised him those 12 years that adopted him. Story 4. Learned while my client was on the stand that she had a little bit of a drug problem. She disclosed immediately after that she was going to fail the drug test the judge ordered because she had been a daily meth user for years. She was stunningly gorgeous, had held the same job for over 25 years, and was a rock star mom to a kid with special needs. Unlike 90% of my clients, she was always on time, responsive, and did everything I asked. To date, the only high-functioning meth user I've met, but damn, that hearing would have gone quite differently had she mentioned that to me beforehand. FYI, most of the time we can deal with bad facts. At the very least, we can give you the advice you need to hear, but there isn't much I can do with surprise facts in the middle of a trial. Story 5. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller and I'm not particularly forceful, but even I was reaching my limit. I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally get a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a popped balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy, but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts. So naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Story 6. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a shootout on the interstate in the middle of the night in a rural area at least. She was the passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to Schmidt, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story for what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge, really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact there was another car obviously shooting at my client, even though the genesis of the shootout was just up the road in that same post's jurisdiction. Short of it was she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks from trial in passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point, the case was 7 or 8 months old. So I look through the discovery again, don't see anything, but file a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as damn, unethical, and common practice for that prosecutor office. I get the interview, and all of 4 minutes in, she tells the cop not only did she know the gun was in the car, but that she had been the one shooting. That pretty much killed every defense I had. We had to come to Jesus talk the next day, and she took her offer, which was the minimum of 5 years to serve. Story 7. I was representing a man that was accused of sexually assaulting the young daughter of his girlfriend, who was married to another man. The key issue was whether or not my client's DNA profile should have been at the scene. Only skin cell tissue had been recovered, not seminal bodily fluid DNA. And it was not an exact match, but rather a match to a profile that included him. A few weeks before trial, he finally told me that the woman's other son was likely his. They had been having an affair for more than 5 years. The fact that the boy shared his DNA was a pivotal reason that the DNA profile would have been present. Edit. Grammar. A big issue was a language barrier, as my client did not speak English, and we used an interpreter for all of our communications. Story 8. Client comes to me with his new wife, complaining that he's been sued by his ex-wife for failing to pay a $5,000 judgment to the ex as part of the divorce decree. Judge orders us to mediation. During mediation, ex-wife won't budge that she wants the full $5K. Client claims he doesn't have the ability to pay it. New wife, in an effort to get her loving husband free from the clutches of his evil ex, offers to give up her large diamond wedding ring to the evil ex. Ex can keep it, sell it, whatever, but client had previously told new wife it was worth more than $5K, so it should be enough. Ex-wife agrees to accept new wife's ring, subject to an appraisal. Maybe you can see where this is going? Get a call. 2 weeks later from opposing counsel. Deal is off. Why? I ask. Turns out the ring was a CZ, worth about $95. When client met with me and I showed him the appraisal, he said, "Yeah, I knew that was going to happen." I stared at him slack-jawed and said, "You knew?" "Oh yeah, but what was I supposed to do? Tell my wife I got her a fake ring? How about telling her, 'No, my love, I gave you that ring, and it is a symbol of my love for you, and that horrible will get it over my dead body. I'll find another way to pay her," I said. He looked at me and says, "Yeah, that would probably have worked." Story 9. Had a guy with a DUI. Asked about any criminal history, he said no. So I started the paperwork for ARD for him. It's a first-time offense program that seals the record and drops the charges once completed. Get to the courthouse, talk to the DA, find out the guy had another Dewey a year prior. Also was on probation from the first one still. His excuse for not telling me was the first Dewey was made up and he wasn't intoxicated, but pled guilty anyway. Unfortunately, I ended up representing him for both bases. Did not get paid nearly enough for the Schmidt I went through, but I did manage to keep him out of jail so he could take care of his elderly mother. Made him give up his vehicles, though. Story 10. I had a client on a family matter. We were in court, and I was going on about how being a father was the most important thing in the world to him, and his ex pipes up and says, well, he never sees his other children. I'm sorry, other children? That being said, many clients leave out embarrassing things until they get called out on them. Please tell your lawyers all the facts. We've literally heard everything and really don't care. Just let me prepare to explain that your weekend habits of cocaine and sex dungeons doesn't affect your ability to parent. Story 11. Spent several hours zealously arguing that my client was severely disabled and couldn't work due to a back injury. It was so bad that the poor dude couldn't even sit in a chair throughout the entire proceedings. Rest my case. Opposing counsel calls in a deck representative who proceeds to produce record after record of my client's deer hunting activities. He sat in a tree in freezing weather for many hours, shot and killed multiple deer, and transported their carcasses out of the woods all on his own. Story 12. My favorite, the plaintiff on the other side, so no attorney-client privilege issues here, was in court telling the judge that each of my clients, on separate occasions, raped and impregnated her without her consent. This was already highly improbable because one of my clients was biologically female and couldn't have impregnated her. Then, in court in front of the judge, this plaintiff abruptly mentions that she's never met my clients. Easiest win I ever got. Story 13. As a solicitor, one of the most annoying things I've had happen was, after an hour-long consultation with an older couple about changing the husband's will, the wife hands me a letter from his doctor which says the husband has dementia and does not have capacity to sign medical documents. Like, you didn't think that was a good place to start? Story 14. Special ed case. School district was supposed to be providing services to the child in the home. Clients told us the school district had never sent anyone to provide the services. They hadn't heard from anyone in the district about scheduling, etc. Brought this up during a pre-hearing conference with judge and opposing counsel. After the conference, opposing counsel sends me pages of affidavits and documentation of all the times the school district employees went to the house and were refused entry by my clients for various reasons. Or clients just didn't answer the door when they were clearly home. Clients had no explanation about why they lied to me. They fired us shortly after, and I was not sad. Story 15. Here's another. I wasn't actually an attorney yet. I was clerking for a firm and helping other attorneys on cases. We had a personal injury case for a car accident. Guy got rear-ended by a very wealthy doctor. He was never going to be able to work again, mid-30s. Life completely ruined because she was staring at her phone while merging onto a highway going 15 mph over the speed limit. The case was set for trial. That's an automatic red flag, as 99% of them settle. No one wants to risk the trial. Couldn't figure out why. We thought we would get him around 2.2 million. Other side was offering 700K. So I'm going through the massive file trying to figure out what they have that we don't know about. Looking at his medical, I saw he tested positive for meth a few months after the accident. I was part of the jury selection that morning, and we had 2 people with doctorates, several with masters and professional licenses, most college educated. Really not good for a guy who didn't make it through high school and was a laborer who decided to sit at home and smoke meth after his accident. Ended up settling right before the trial was supposed to start. We got a little more out of them, but far below what we expected. The guy was adamant about not settling, but we talked him into it. He would have been screwed as soon as they brought that up. Story 16. In-house attorney here, but I interned for a judge at our Court of Common Pleas during law school. There was a case of a guy that asked 2 early 20 girls a ride from the mall to a gas station. He told them he would pay them cash for the trip. During that trip, he sat in the back seat and had advised that he had a pellet gun that closely resembled a handgun. He said he had only pulled it out to show the girls, but never did anything further. That had been his testimony during all the proceedings. He willingly takes the stand, and the prosecutor's questioning him about the gun and how he handled it. This dude willingly admits that he held it to the passenger's temple, threatening to shoot her with what she believed to be a real gun. He also corrected the prosecutor during questioning, telling him that he never stated it wasn't a real handgun. That jury verdict came about as fast as one could. Story 17 was prosecuting a simple assault and battery. Story I get before trial is, baby daddy shows up and punches new boyfriend before leaving with the kid, who TBF he has custody of because mom tested positive for coke at birth. At the time, girlfriend baby mama tells police, yup, that's what happened. But in the meantime, she and new boyfriend broke up and now she's back with baby daddy. So her story has changed and she is saying it didn't happen. She isn't credible, so I discount her new version of events and still put the case in front of a jury because the victim is adamant and there was an injury to his face. Defense obviously puts the girl on the stand, where it first comes out that she and the victim weren't Netflix and chilling as reported to police, but were actually doing cocaine and ignoring the baby. The baby daddy apparently knew she did coke at this location, so when he saw her car there, he went and pounded on the door demanding their kid. She then says that the victim hit himself in the face to make it look like he was beat up. As she's saying this, the victim starts hitting himself in the head and yelling, "No, no, no," like the special needs kid the school makes wear a helmet, before storming out. The jury went with not guilty, and I understood. Story 18. Okay, here we go. Defending a lady in a simple neighbor dispute. Neighbor said she assaulted them with a hose and threatened their kids. Case was pretty weak. My client was an old lady and she adamantly denied everything. Anyways, it's just a small evidentiary hearing in front of the judge, so there was no discovery ahead of time or anything like that. Anyways, my client is on the stand. Come to find out, they have video footage of her smearing dog Schmidt on their house, printing out photos of their kids, and writing racial slurs on them. Family was Jewish, and covering her house with racist signs like papering her entire house. Needless to say, my jaw dropped. Client then perjured herself on the stand. They play a video where it's obviously her, but she repeats, "That's not me," over and over. Most painful court moment of my life. Story 19. So, not a lawyer yet, but I interned at a family court helping during hearings. There was this woman filling for custody of her children, and her lawyer was pretty confident they'd win. Since in my country, women getting the custody is almost an unspoken rule. In the rare cases they don't. Either they don't want it, or there's a very strong reason for the children not to be with their mother. So, as I was saying, her lawyer seemed very confident. It was practically a one case, until her client's ex-husband mentioned in the middle of the hearing that his ex-wife was an addict and lived in a non-monogamous relationship with 2 other addicts. To make matters worse, the woman's parents confirmed his story. The lawyer very obviously did not know about it and was visibly pissed at her client. I swear I saw her mouth to the woman, "You'll have to find a new lawyer." Story 20. Working on a file for a non-EU company, participating in a public tender within the EU. To summarize in a nutshell, when a government agency needs to build something like a building or a bridge, they have to organize what is called a tender procedure to weed out the charlatans, fraudsters, and to enter into a contract with the most advantageous tenderer. Such a procedure is organized according to strict rules, and a lot of things are public to ensure equal opportunities for every company and to prevent bribery, collusion, fraud, etc. Serious stuff. One of the conditions to be eligible for such a tender is that your company and its directors have not been found guilty for certain crimes, e.g. breaking labor laws, money laundering, corruption, as you're assumed to be untrustworthy. If you had such an issue in the past, you can fess up and try to argue this risk has been eliminated thanks to a self-cleaning procedure, getting rid of the bad apples in your company, basically. Our client assured us that they never had any such issues, were never convicted, yada yada. Just one of the many steps in a procurement procedure. Years later, when the construction was well underway, it turned out they lied and directors in their home country had been found guilty for bribery of government officials. The contracting authority got rightfully spooked and argued. Our client willfully lied when tendering for the contract. The consequence is that you were never eligible in the first place, and retroactively, the tender should be annulled to restart the procedure. When asking our client WTF happened and why they didn't tell us so, we could have tried to argue the self-cleaning exemption. They said that they didn't think it seemed relevant. It was widely known in newspapers, in the language of their home country. So, they assumed they didn't have to tell the authorities. And besides, many CEOs in their home country get convicted of bribery and pardoned when the opposite party gets reelected. So what's the big deal? Literal millions of dollars and several years of thousands of people's energy down the drain because they lied on a form. Story 21. Immigration deportation defense case. Our defense against deportation required showing exceptional and extremely unusual hardship that my client's U.S. citizen children would suffer if he was deported. I had reviewed the law and facts of the case with him ad nauseum. He and his wife had reviewed their testimony with me a number of times. The children's hardship did not seem like it would be strong enough to win the case, because the parents told me that the kids were relatively healthy, doing well in school, and didn't have any other noteworthy issues. All of the documents that they brought in supported their testimony. While testifying in court, the wife admits that they have a child that they had not mentioned before, with a rare medical condition that required trips across the state to see a specialist every few months. During a short recess, so I could figure out why they hadn't disclosed this at any point in the last 3 years, they confessed that a family member who knew a lot about this stuff told them that having a citizen child with a serious medical condition hurt their case. The judge denied my request for a continuance to get evidence and expert testimony for the medical issue because they had ample time to provide the evidence before and hadn't disclosed this. And ultimately, the judge denied the application because he found that that portion of their testimony lacked credibility due to it being disclosed at trial, and they hadn't provided corroborating evidence. Story 22. Police officer. I know, Mr. Defendant. I've arrested him on 3 prior occasions and he always gets away. After 7 attempts to prep this witness to find out what can kill the case and his career, he stonewalled me every time. I even said I'd prep him during his night shift. This case hinged upon the police officer's credibility. Now the police officer shocks the court and me with his bias against the defendant. Anyway, if I knew about this bias, I would have dismissed the case. Now the police officer is on an official court, ruling as a non-credible witness. His career is over, all because he decided he was too important to be prepped as a witness. If I didn't document every time I contacted him to schedule prepping, I would have had hell to pay at my office. Story 23. There was a temporary order of protection in place, and we went to court on the lengthier order of protection. I talked strategy with my client the night before, but unbeknownst to me, she reconciled with her abusive Schmidtbag baby daddy. I had 3 op hearings that morning and did not get a chance to talk to her until 3 minutes beforehand. We had the wrong judge. I knew as soon as she told me she was going to be arrested for violating the temporary order. Sure enough, they both got a week of jail, and I had to watch their 3-week-old child for a few minutes before a bailiff carted her off to God knows where. They both got fired for missing a week of work. They couldn't get the kid out of the system. Evicted, homeless, the whole 9 yards. All she had to do was tell me they got back together. All she had to do. Story 24. I had a client charged with shooting and paralyzing victim. He was ID'd by a woman in the house that knew him, but the witness was potentially biased. Client says he wants to fight the case. We then discuss whether it should proceed time waived or time not waived. The difference is how quickly the case is set for trial. Time not waived means the trial is set within 60 days. Time waived means the trial can start in more than 60 days. The importance was that my client told me he was not at the scene. I stressed the importance of being honest and that everything is confidential. He again said he was not at the scene. I told him we could get cell phone records to confirm that his phone was not at the scene of the crime at the time of the shooting. And if we could show that it was active, meaning he was using it, it could help cement his alibi. I also said, but if you were at the scene, we should set this time not waived so the DA can't get your cell phone records. Client says to set it time waived and get the records. So, several months and a lot of work later, the cell phone records literally show him at the damning crime scene at the time of the shooting. It also leads to more evidence, more directly linking him to the shooting. The records also managed to implicate his friend as being involved. It tuned the case from being borderline to a slam dunk for the DA. It's even more ridiculous than this, but it's kind of off topic. Edit. Okay, some more of the ridiculousness. I share the details of the cell phone data with client. He has no reaction and offers no explanation for his prior statement that he wasn't at the scene. I explain that the DA does not yet have this information, so we should try and accept a deal now before the DA finds out, because he will most likely revoke the current offer when he does. Client insists on a jury trial. I explain that it's client's call whether we go to trial or not. I'm here to offer advice, and he's free to reject that advice. But I think it's a really bad idea because the DA will get the info before trial. When he does, the offer is going to skyrocket. Client continues to insist on a trial. My final words are, that's your call, but commit to your decision. If you reject the current offer, then try and plea later. The offer is going to go through the roof. If you want to plea, do it now. You guessed it. The jury is literally walking into the courtroom, and I hear this, psh, psst. I look over and ask him what's up. He says, I know you said not to do this, but I want a deal. He pled. Because of his shenanigans, his offer increased by roughly 300%. He would be out of prison if he took his original offer, and I think he has well over a decade to go currently. There's actually more, but I don't think I can share it because it's so unique that it would make it easy to identify the case. Edit number 2. Wow. Thanks for the award. My first. Story 25. Criminal defense. Canada. Talked to a client in cells. Said that she was hanging out at her baby daddy's, and then, as she was leaving, the cops came and harassed her, so she resisted, and that is why she is in jail. Turns out, she was getting aggressive with him, and he kept trying to get away from her. He ended up calling the police. While he was on the phone with the police, she starts beating him up. The police hear this and immediately respond. She was trying to flee the scene after beating her man up while he was on the phone with the cops because he was attempting to passively solve the issue, but she wouldn't leave. Luckily, she has no record, but man, I felt bamboozled. I learned a healthy dose of skepticism whenever people told me things from there on out. You gotta love it. Story 26. This isn't quite as good as the others in this thread, but once I was representing a dude pro bono who was suing the cops for beating the Schmidt out of him after they had arrested him. He had led them on a high-speed chase through the suburbs, which was already not great, but the rule of law should apply to everyone, and the cops are not allowed to beat the Schmidt out of you after you've been restrained. So a tough case, but whatever. You're the lawyer. You do what you can. In one of our first meetings with him, we're going over that night. I asked if he had had anything to drink, and he admitted that he had. A beer or two around 8 p.m. The chase was at 2 a.m. And as you should know, alcohol leaves the system at a rate of roughly 1 drink per hour. So we were probably fine there, and if anything, it was nice to have a client who wasn't pretending everything was perfect. We move on and talk about the rest of the night. Then as we're wrapping up, our damning summer intern of all people goes, "Did you do any other substances that night besides alcohol?" And the client's like, "Oh, right, yeah. Some marijuana and some coke." Dude, you didn't think that was relevant when we were talking about a couple beers? The lesson I took there was that the ones who are the most charming are the ones you have to press the most. Story 27. Doing a complicated environmental permit case for a client. Permit was granted at the city level, but the neighbors, who were not too thrilled about a business the size of our clients being next door with loud trucks moving around all day, appealed it. They have a ton of remarks, but we can deflect most of the legal ones, and the only issues that really remain are that the plans are a tad bit vague, and the noise issues, for which a study was ordered but not yet completed, to give a 100% guarantee there would not be sound regulation issues. To clear up the last questions, the state body did a planned on-site visit to get clarification on the few things that were not clear on the plans and the things that were filed. My firm was not notified of this visit, and as such, we were not present during this visit. Client handled it himself with his architect. They called us the next day to inform us of the following. During the visit, state body personnel had noticed that the sewage and plumbing system didn't really appear the way it was always drawn and shown, and also granted as part of the initial permit. So they asked client to clarify where their dirty water went. Client, architect, supposedly responded with, "Oh, that just gets collected and drained down to the little stream at the back of the lot." Client wanted to know if that was bad. Spoiler alert, yes. Yes, it was. There was no fixing it either. This was a company with potential environmental issues due to fluid leakage from machines and car park. So they had a ton of rules to follow on how to deal with your dirty and used water. Separators, containment, early collection, and so on. They'd drawn most of these in their plans and were assumed to have all of this installed and working for the 20-something years that they had already been running their business on that site. According to their past permits, that needed to have those things. Announcing in the middle of an appeal procedure, so no big changes can be made to the contents of your permit request, that instead of a finely tuned sewage and waste management infrastructure that the government believes you have, you just have one big pipe chucking your water in a small stream at the back of your lot is bad. We had to explain to the client that no, we can't fix this, and yes, you should have told us about this from the start, and is there anything else you might have not mentioned that you need to tell us about? Story 28. I shared this earlier in a thread, but I work in medical malpractice defense. Once I had an obstetrician gynecologist who severely burned a patient during a procedure. When I met with the doctor, he lied to me throughout the representation over 16 months, saying he had no idea how it happened. There is a doctrine in law called res ipsa, meaning absent some sort of negligence. This accident could not have occurred. Woman came in without a burn, and after the procedure, the woman left with a burn the size of a dinner plate. There's no way this doctor didn't know what had happened. The area of the burn was where he was operating on. It wasn't until I brought up settlement, because this was not a case we could win, did he say, "Oh, maybe I do know what happened." We ultimately settled that case, which is considered a favorable outcome considering the potential high monetary verdict. Sometimes I think this doctor really ought to have lost that case in their license. Eventually, it was discovered that the lamp used to illuminate the site of the procedure emitted a ton of heat, enough to cause serious burns. Story 29. Divorced client came into my lobby one morning, panicked. She starts screaming about how the money was missing. "What money?" I asked her. Apparently, her and her soon-to-be ex didn't believe in banks, as they kept a suitcase with close to $100K in a safe in their bedroom closet. One morning, she saw the safe was open and the money was all gone. Y'all have no idea how hard it is to trace and prove the existence of that much money in loose 100s, 50s, and 20s. Cost her several grand in fees alone for how much work went into finding it, when if she had just told us about it, we could have placed it into a trust account pending the divorce. Story 30. How about a tiny twist? With some lawyer-on-lawyer shenanigans, other lawyer filed a document with a pretty big mistake on it. Basically, they confused two very similar motions and mixed them up. This mistake made it useless. No evidence MSJ with traditional MSJ relief requested if anyone cares. So I go out of my way to be a nice lawyer and let them know they made a mistake. They told me in nice lawyer talk to damn off. I go out of my way again to say, in nice lawyer talk, that if this stupid bullshit motion goes to a hearing, I will be quite cross and will ask for attorney's fees. In lawyer culture, This is considered a dick move. Fast forward to the hearing. After insurance attorney finishes their impersonation of a competent attorney, I explain the basic defect to the judge. I also explain that I told opposing counsel the following: what's wrong, how to fix it, and that I will be asking for fees. Then I asked for fees. After that, a few things happen quickly. 1. Judge asks the Walnut if my explanation was accurate. 2. Walnut says no. 3. I reach into my briefcase and grab an email from me to Walnut. 4. Walnut immediately objects. In a pretrial hearing, like a Walnut. 5. Judge ignores Walnut and reads email. 6. Judge rules against Walnut and awards fee. 7. Walnut says I should have mentioned the email sooner. Story 31. My client had a no-contact order with his ex-girlfriend. He got a call and hang up, dialed Nishir 69. It was her. She called the police saying he had violated the no-contact order. We show up to court, and I think I have a pretty good argument on his side. 2 police officers walk up to me and look at my client's name on my case folder when he was in the restroom. When he comes back, they arrest him on an outstanding warrant for armed robbery. I get a continuance for his case. His car gets impounded in the garage. I can't get him transported from the jail to face his violation of a protection order, because that is how the police worked in that city. The public defender takes over his cases. I moved away shortly after that, but that was a very bad day for my client. I stopped putting names on my case files after that, so no prosecutor or police officer would be tempted to look through them. Story 32. Oh man, one I can answer. I used to work in-house for a fast food franchisor. Occasionally, we would litigate against poor restaurant operators. Restaurants were evaluated with some frequency, and operators had a lot of opportunity to fix problems before it ever got to litigation. But almost all of our case relied upon the testimony of an individual evaluator assigned to that restaurant and the reports they produced. A week before the hearing, I call up my witness to do standard witness prep. I walk through all of the basic questions, the reports themselves, and some of the anticipated cross-examination questions. Everything goes well. Witness is confident, reports look good, and there aren't any curveballs in his prep. I even ask my tried and true safety question at the end. Is there anything we haven't discussed, good or bad, that you think I should know? Nope, I think I'm all set. We get into the hearing. I run through all of my evidence. All is planned. Restaurant operator gets up to cross-examine my witness. First question. Roe: did you fall asleep in my restaurant while you were preparing this report? Witness: yes. Restaurant owner made him look like a drug addict. Thankfully, I was able to get a brief moment with my witness before redirect, and I learned that it was a medical issue. We still won that one, but what if? Story 33. My father was handling a case of his friend's family about a property that this friend and his brothers and sister inherited. Horrible mess, as you can imagine. Deeply conflicted family. After a few years on one of the court, hearing one brother mentioned a name that never appeared during the entire lawsuit. Turns out there was one more brother that they all decided to not mention because he was a black sheep of the family. Years of tiring work went down the drain. From what I understand, my father, who was doing it all for free because he owed him, got into argument with this friend. They never spoke to each other again, and guy found a new lawyer. Story 34. Child custody case, where I represented grandparents seeking conservatorship of a preteen girl from bad bio parents. Asked all the usual questions in preparation about their home, who lives there, any criminal or CPS history, who the child would be around or alone with. Nothing remarkable. Child care plan involved the girl riding bus home from school and spending a couple of hours at home before grandparents returned from work. During the hearing, it comes out on cross of my client that their son, who had recently been released from prison and is required to register as a sex offender, was residing in a trailer home on the property, where he would have a couple hours per school day with potential access to the child. We still won because the parents were horrible. Client later explained that we only asked them about people living in the home, and it didn't seem relevant to them. Facepalm. In our firm, crucial information the client didn't tell us is referred to as having a sex offender living in the backyard. Story 35. The lawsuit was the first time I heard about the case, Osh claimed. I called up the manager and asked, and he denied knowing anything. I held 3 separate interviews with him and his staff, and all said nothing happened that day. We prepared a defense of Bullschmidt. At the manager's deposition, after the standard state you name, etc., the first question the plaintiff's attorney asked was, "Do you recognize my client?" "Oh yeah, now that I see her, I remember." Story 36. Client asked a friendly company to forge documents to provide evidence of a fair rate for defect rectification works. A whistleblower told the Corruption Investigations Board, destroyed their credibility for the whole claim, even where there was good grounds, and ended up in a whole criminal investigation. Great billings for us, though. Story 37. So this will probably get buried, but it's a good one I saw. A colleague of mine is working a child custody case as court-appointed counsel for the mom. Mom had some of her own issues, but the child was taken after she and her BF posted a video on social media of them smoking a blunt with the kid in the room. That's child endangerment. At trial, mom takes the stand and says it wasn't really a blunt, even though that's how they refer to it in the videos, but rather a blunt. The distinction being that once they opened the wrap and removed the tobacco, they had actually replaced it with another type of tobacco. Okay, not great, but not the end. Judge asks mom what she did for a living. Remember now, mom filled out a sworn affidavit saying she can afford an attorney and needs the state to pay for one. Hence, my colleague's appointment. Mom thinking that a high income would bode well for her chances of getting her kid back. Spoiler, it didn't. Says that she works part-time at a fast food joint. Knew that one. She said she also worked as an exotic dancer, but hadn't been able to since COVID. Knew that one too. She then goes on to say that she also braids hair and does nails on the side, and that she averages about $5,000 a month. Her affidavit shows she makes less than $1,200 a month. The judge was nice and didn't charge her with perjury and tried to give her every chance to walk those numbers back, but she refused. Based on testimony, she lost custody, and child support was set based on her income, claimed from the stand. I've never seen him pinch the bridge of his nose so hard or for so long. Story 38. Here's a story of a $1 billion+ screw-up. A few years ago, I was involved in a family business dispute concerning ownership and control over a small conglomerate of oil and gas companies out in Midwest. Total value of the Copers was $1 billion+. Umbrella entity was an S-corp with Pops at the reins and several kids as 100% shareholders, aka owners. Pops held no stock and was CEO press, but not an actual owner. They had a verbal agreement within the fam that Pops runs the biz until he is ready to pass it to kids. But until then, they do not interfere and just reap the benefits. In fact, kids were in their 50s and did Jack Schmidt their entire lives being billionaire trust fund babies. No knack or experience running such a high net worth operation to speak of. Now Pops was in his mid-80s at the time, but still sharp as an arrow and as feisty of a biz shark as ever. An important fact here is that he often made unconventional biz decisions and frequently dabbled into very risky investments. E.g., he could easily lose 10 mil in a clearly dead-end project, but make 50 on another equally insane one. Back to our times, kids, as S-corp shareholders, get to pay the taxes that pass through the entities to them. And we are talking hundreds of millions in taxes. Pops' entities would always give the cash so kids could pay. Lately, kids felt that Pops was getting too extreme with his investments and potentially subjected them to close to 200 mil in taxes that they had no money to cover themselves in case corp funds got wasted. So what do? They fire Pops from the companies and take over as owners and now officers. We sue to enforce the family agreement and also recover what is known as the quantum meruit, aka Pop's fair value of services over 40+ years. He ran the fam biz. Kids fight tooth and nail not to give up control, and their main driver is that Pops is going senile and will just piss away the family fortune with his risky biz calls, while they will be on the hook for 200+ mil in taxes that they won't be able to pay. We do a monster of a job, showing that Pops is as sharp as ever, does great job at investing and multiplying fam money, and should remain in control. Settlement is not an option, because both sides want to run the show, so we are roughly a month from trial. By all the accounts, we were going to win the trial at this point. And this is where our brilliant investor superstar decides to withdraw 20 mil from Corp ACCs for personal use that he felt he was entitled to, and proceeds to invest another 10 mil of Corp funds in a project that is akin to the Nigerian Prince email scam. Send me 10 mil and I'll return 100 mil in a month kind of scenario. Did not tell us, his counsel, or anyone about it, despite our repeat instructions to consult with us on anything more than taking a piss, and 100% of everything business related, even if it was paying for a cab with BizCard. Nope, we found out about the whole withdrawal and investment ordeal from none other than Kids Counsel. Unsurprisingly, their lawyers had a field day with this withdrawal and scam investment at trial to portray him as a senile old fart incapable of managing anything. Jury bought it, kids won the trial, and retained control of the companies, while Pops got nothing but a, "You can live with us, Dad, and we'll take care of you." Story 39. With some clients, mention it sooner means I never mention anything that might hurt my case. Like the case I recently had where I sued an electrical contractor based on their assertion that they had paid the guy to replace a box, and he had left them with half their lights not working. What they didn't tell me is that they had an illegally installed secondary box dog-legged off the first box that was controlling those lights, and he had to disconnect that box because it presented a massive danger and code violation. Then they didn't want to pay him to correct the second box. I have plenty of cases some important fact was left out. That's why when I take notes from a client, I have them sign at the bottom that I did not leave anything out. I had a persistent felony offender early in my career who told me this sob story about how she had lost her baby and it drove her back into drugs and breaking the law. I asked her about it during sentencing. The prosecutor gets up and he is familiar with her. He leads with, "Are you still using the baby you killed 14 years ago as a crutch for your bad decisions?" Story 40. Mexican lawyer here, working on Mexico, so the terminology is not going to be exactly the same. Also, my English is not perfect. Basically, one day I get a person who brings his mother on a wheelchair. They said a week prior that while pushing his mom wheelchair through a parking lot, the mom got hit by a truck who was moving in reverse out of parking. The mom fell to the ground and hit her head and hip. The dude on the truck convinced the son to not call the police and that he would cover the medical expenses. He didn't have insurance. Mind you, down here, medical expenses are generally not total money. Black holes like in the US, most minor things you can be covered out of pocket without insurance. Truck guys gives them their name and tells them he owns a small car parts shop next to the parking lot. The son then takes the mom to the medic and gives her some painkillers and other medicine after checking. She doesn't have anything more serious. A week later, when they come to my office, they said the mom has been having strong head pains and that her hip is not healing. They went to the truck guy to ask him to pay for the studies and medicines, and he refused. I take the case and start a lawsuit for lesions and medical expenses. Skipping some parts of the process, we end up taking the case to legal mediation. Down here, some minors cases can be put on mediation to be resolved before going into a full-blown legal fight. This to avoid saturating the system with minor stuff. During the mediation, it comes out that the truck driver not only did offer to take the mom to the hospital himself and pay all the medical expenses on the spot, and my client refused to let his mom get taken to the doctor by this dude. But on top of that, my client also accepted a small sum of money, 1,000 pesos, which is something along $50, which is not a lot for the US, but is enough to pay a couple weeks of food down here. When originally he said to me that the truck guy didn't give him any money, I was fuming and angry as damn. I wanted to drop the case there and then, but my boss told me not to. Anyway, the mediation didn't get anywhere, and a month later, I ended up dropping him as my client after I asked him to give me the tickets, receipts of the medication expenses, and the guy decided to bring me fake tickets where he said he was charged like 500 pesos for a 30 pesos medicine, and the real receipts were from 2 months from before the accident. When I declined to receive this as evidence, he called me corrupt and go away really angry. I was really upset at myself because I actually did buy some of the medicines the mom needed. I do believe the mom got hurt, but his son was obviously just behind the money with no care for his mom. Story 41. This was before I was a lawyer, but I was interning for a judge. I really have to set the stage to make this make sense. The line is where the story really begins. Drug court is a simple thing. Basically, we don't want to throw people in jail for drugs. Instead, there are meetings, counselors, and really everything else you can possibly want. Convinced you can't quit on your own? Sure, impatient it is. You generally get the idea we are all on the same side. To the point the prosecution and defense attorneys are so cordial that collectively everyone almost always comes to an agreement. The defendants, which are called that in the loosest possible way, and only because it does allow for a jail sentence if they don't complete their rehab or whatever, are entirely aware of this. It isn't a normal go and get sentenced and never see the judge again kind of thing. We did monthly meetings to go over drug results, and really the judge knew each of them, as in took notes and would ask how the new job is going. Even positive drug tests weren't really a big deal, as long as it was clear that the person was trying. We go through the morning talking in chambers with the attorneys and everyone else present. Basically, probation, drug counselors, the judge, his staff, everyone but the defendants. The usual X failed after Y months and tested positive. Kind of go through, but because of the quantity, think 50 plus on a good day. It is a once a week thing. It is possible that someone gets skipped here, and it really is largely reliant on the defendant being honest with the attorney. Krupflian, so judge calls X to the stand and opens the envelope with the drug screen and file as a whole. He asks her what happened. Obviously, something was positive that shouldn't have been. At this point, her attorney is reaching for his file because he didn't know anything was positive. She tells the story. It starts out a relatively drawn-out comment. She took a bus to the methadone clinic and got her treatment. Then she walked out, and this guy asked if she wanted any fire-ass dope, And she casually said sure. The judge asked her to say it again, obviously as a try to use better language way. What followed was essentially the littering and moment in Super Troopers, with her and the judge, fire-ass dope. He offered you fire? Yes, fire-ass dope. Fire-ass dope was the phrase he used? Yes, he said fire-ass dope, while her attorney went from subtly trying to whisper to outright saying to quit saying it, while the rest of us fought back the obvious need to laugh at the absurdity. Story 42. I have a client who was charged with violating his probation a second time. He was a good talker and had a good story about how he's an addict. He sweet-talked the judge on the first violation and got a couple months of active jail time. Most importantly, he was continuing to say that he was just a user that slipped up and wanted to get help. At the hearing on the second violation, the prosecutor brought in 2 police officers as witnesses unexpectedly, and they testified that when responding to an overdose, the phone next to the dead body lit up. The phone lit up with a message from my client saying, "I am not going to deal to you anymore because you don't show or are late always." The police then go talk to my client, whom explains that he wasn't giving her heroin, only Molly. When he tries to explain this situation on the stand, the prosecutor asks him why the 2 times he was arrested on probation, he only had heroin on him and not Molly. He was not charged in connection with the dead body, so there was no indication of that event before the trial. And the client neglected to inform me that he was involved and talked to the police about that event. At that point, the multi-year offer was gone and he will be doing more than a decade. Story 43. Paralegal for insurance defense. One of my first cases, I was completing discovery with a very young client, barely 18. She claimed the city bus rear-ended her when she was slowing to make a turn. Then he got out of the bus, yelling at her and screaming expletives. We submitted these responses. We come to find out months later, there is actually video on the city bus, of course, of her trying to make an illegal U-turn and ramming herself into the side of the bus. Then she got out of the car and started screaming at the bus driver, who stayed silent in his bus. The video also caught her on her phone. Not the smartest person I've met. Story 44. By far the most egregious I've had was in the middle of a workers' compensation mediation. My client had suffered an injury on a worksite job, and the mediation was going okay. He was hoping for the stars, moon, and sun, but the employer was offering something that was fair enough to take. Then my client pulls me aside hours into the mediation and tells me for the first time in the entire course of representing him over a year that the injury he suffered at work was really from a previous injury he had at a prior job. In other words, he didn't have a workers' comp case at all. And all because he wasn't honest with me for over a year. I flat out told him that he needed to take the settlement offer right then and there and walk away from the case, or else I would have to. Fortunately, he did take the settlement. Unfortunately, he and his wife badmouthed me and called me a bad lawyer to pretty much anyone they could talk to. They didn't go to the bar or anything, but it's super petty to turn around and say someone's bad because you lied to them. Of course, I'm used to it now. It stung a little way back then though, and this isn't like some of my other clients who have a drug problem, lie about it, and cannot accept that they have a drug problem. This guy knew exactly what he was doing. He lied to me to get me to take his case. If I had been more experienced, maybe I would have caught something in his older medical records, but the other side didn't either. Story 45. My cousin was the moron client. He and his second wife are divorcing, and she wants full custody of the kids. No visitation, just lots of child support. He's willing to a 50-50 split at first and finds an attorney for the case. They're going over everything when he casually mentions how the mom drugs them literally every night so they sleep and she can go out to the bars while he works the night shift. Cousin thought this was his smoking gun to beat her in the custody battle. Attorney had to explain that, no, you can't tell this to the judge or that you've known she's been doing this for years. You'll both lose the kids and they'll go to state custody. Both of them are petty and incompetent, and as you can imagine, we don't interact with that side of the family much. This has all been retold to me by other relatives. So don't worry, CPS was informed of all of this. I do not know the outcome yet. I'd have to ask. Story 46. Defending a tenant from eviction. The client kept saying she was being evicted because the police were called after her abusive ex showed up. That's actually discrimination, leaving the landlord liable if that was the reason. But landlord's attorney says they're evicting for cause, not the ex thing, and asks whether the tenant told us what she did. I go back and ask if there's anything she hasn't told us. Well, maybe it's the fire I started in the laundry room. I was really coked up, and the security footage looks bad. This is about 5 minutes before the judge calls the case from the bench. Woof! Story 47. In law school, I had an internship at a defense contractor. Most of my work related to disagreements with government auditors regarding whether expenses were appropriately being charged to government contracts. One of the issues was how much of the cost of the executive jet could be charged. After a lot of research, arguments, and negotiation, I was successful in getting the expenses allowed. After reporting my success, my supervisor congratulated me and proceeded to inform me that the executives would be pleased because a second executive jet had already been purchased and had yet to be disclosed to the auditor. I felt very used. The info was very intentionally kept from me until after the successful first round of negotiations with the auditor. I did not seek employment there after the end of my internship. Story 48. I've told this story elsewhere, and possibly on another account. But when I was in law school, I interned for a judge. You had to apply to get into the internship program, but the judges were randomly assigned after that. And with my luck, I ended up in family court. I didn't really have any interest in family law, but it was still an interesting experience, mostly because some of the cases I observed were highly entertaining. One case that sticks out in particular was a matter about a spousal support dispute. The couple had been divorced for a few years, there was no longer child support involved, and the man had since remarried. He had gained new dependents, according to him. His income had gone down, and it had been long enough that his ex-wife could have started working again, though she chose not to. She also had unpaid renters residing with her. On the surface, these sounded like reasonable points for why spousal support should have been decreased or eliminated. As soon as they started delving into the case, though, it turned into an absolute Schmidt show. It was true that he had remarried. He'd married his secretary, who it was alluded to he had left his wife for. His new dependents were her adult daughter and grandson, as well as 16 relatives of varying ages in Mexico. His salary had decreased, but the salary of his wife, who was still his secretary, had gone up by more than the amount his had gone down. His ex-wife didn't work because she was the full-time unpaid nanny for their 2 joint severely autistic grandchildren. The unpaid renters were 2 of their adult children, aged 18 and 20, who were living at home and attending community college, which, incidentally, he refused to pay for, while paying for his stepdaughter to attend an expensive private college. After all this came out, the judge was not happy with the way he had framed it. Spousal support was not revaluated. Story 49. Used to do public defender work. At bond hearings, prosecutors discuss the client's entire criminal history to the judge in an effort to deny bond and make the client seem as dangerous as possible. It always told my clients, I need to know your complete criminal history before we go to the judge, because if it's good, then I'm going to work the angle, and if it's bad, I am just going to keep my mouth shut. But don't lie, because once the prosecutor opens their mouth, if it contradicts what I said, you're going to be the one looking like a liar, not me. I've had a few major blows. Each client told me that they had never ever been arrested before. So that's what I tell the judge. Your Honor, my client deserves to be given a signature bond because they've never been arrested before and are innocent until proven guilty. Well, client 1, convicted of rape at 17 years old. Sealed conviction, so I guess he didn't think it was going to come up. Client 2, convicted of manslaughter, reduced from murder. Client 3, the prosecutor hands me a copy of their criminal history, 17 convictions. I just look at him and ask, did you forget about the 4 felonies you plead guilty to over the past 3 years? Add to clarify. In my office, we didn't receive criminal histories until down the line, so we often went in blind and relied solely on information provided by clients. Story 50. I'm an immigration attorney who does deportation defense. For a couple years, I did work with unaccompanied minors, mostly Central American refugee children fleeing their home country for a multitude of reasons without a parent. So there I was busting my ass off for an asylum case for this one kid. We show up to our court date with the guardian, older brother, to set the trial date with all my filings prepared. Just brother shows up without the kid and says, oh yeah, he wanted to go back to home country. So he did and just left. Well, what would have been a helpful conversation to have with his lawyer is the possibility or consequences of that. They never mentioned anything to me. By just up and leaving, he's self-deported and cannot come back for 10 years. If he had talked to me, I could have cut him a deal for voluntary departure without that 10-year bar. Plus, I did all that work. Man, I still get mad just telling this story now. Story 51, throwaway account. As an articling student, I handled a small claims case for a girl who was pleasant, but none too bright. She broke up with her megalomaniac ex-BF, who drafted up some insane chastity clause agreement, which she signed to stop a barrage of texts and emails. She eventually got a new BF, he caught wind, and held her to the damages provision of his contract. She made the first payment before her mom stepped in and told her to lawyer up. We get him to stop harassing her, by sending a strongly worded letter. 6 months go by, and she gets served with a statement of claim. As I prepare for a motion to strike, she tells me that her mom said she should mention that she also lent this guy $30,000 over the course of her year-long relationship and wants to know if she could get that money back. Yeah, I replied. Why didn't you mention this sooner? You know, I didn't think it was important. Story 52. I cross-examined a character witness. He testified how badly the plaintiff was injured and that they have lived together for the past 3 years. The witness saw how devastating the injury, subject of the suit, was to the plaintiff. Character witness was the brother of the plaintiff. Witness testified that he had not lived anywhere else over the past 3 years, always lived with his brother during that time. So he saw how the injuries affected the plaintiff every single day. The character witness was convicted of raping a child 15 years prior and was a registered sex offender. He moved from another state and failed to register in the current state as a sex offender. About 18 months prior to his testimony, the witness was convicted of failing to register as a sex offender. He was sentenced to 12 months in prison and served 6 months of that sentence in federal pen during the time in which he claimed to be living with his brother. I asked him if he lived anywhere else in the past 3 years several times. His testimony was never anywhere else. I asked him about his child rape conviction, his conviction for failing to register as a sex offender, violation of the terms of his parole. He could not be around children. He also lived with his sister and her small children, and about his time in the federal pen. His response, I forgot about that. He was not a compelling witness, to say the least. I know the other attorney, and we were talking after the case resolved, and he mentioned that the character witness should have mentioned he was a convicted rapist prior to testifying. And yes, the witness was reported for violating his parole. His parole officer was made aware of the living situation. Story 53. In law school, I participated in a year-long clinic where we represented clients in Social Security benefits hearings. Our clients had previously been receiving benefits, but recently had their benefits terminated. I specialized in working with clients who had their juvenile benefits terminated as a result of them turning 18 and not qualifying for adult benefits. My very first client was an 18-year-old who had just entered community college. He was previously receiving benefits due to mental disability as a minor. However, once he turned 18, he no longer qualified as the requirement to receive benefits as an adult is higher. The kid, unfortunately, was losing his benefits due to his standardized test scores and performance in college. I asked to see his first semester transcript and didn't recognize the classes listed. They had a strange designation rather than the standard 100-level class designations. I asked him what they meant, and he told me, that's first-level computer science, that's first-level English, etc. And he told me that's how the college codes all of its classes. So my task, essentially, was to present to an administrative law judge a client who was getting B's and C's in first-level college courses, and to argue that due to his mental disability, he would be unable to find a job. Little did I know until his mother told me right before the hearing. Those are remedial classes offered at the community college for kids with moderate to severe learning disabilities. Yes, it was technically a first-level computer science class, but it was remedial first level, and his course of study would see him top out at potentially a 100-level class his final year. But my client was proud that he was going to college and getting B's and C's. So that's how he presented it when he spoke to me. I was able to amend the brief prior to the hearing. Unfortunately, we still lost. I could sway the judge on the college courses, but the client's standardized test scores were high enough that the career advisor in the case stated the client could potentially find a job. It did change how I approached the other clients, though. I knew they didn't want to be disabled, but I hadn't considered the fact that they would try to present themselves as not being disabled even to a judge when it meant potentially losing benefits. Story 54. I wasn't on the receiving end, but was able to pull it off on the opposing attorney. It involved a wreck where a school bus clipped a car, stopped at a traffic light. It was pretty clear the bus, whose side I represented, was at fault. The main issue was damages. We had attempted early mediation before getting into discovery, but ended up pretty far apart, around $500,000 between the last offers. Plaintiff's attorney then scheduled a deposition to preserve the testimony of plaintiff's doctor. He was referred to the doctor by his attorneys, and the doctor had performed all these procedures and billed exorbitant prices, at least in our view, and there was going to be an issue between the two sides about whether neck and back pain were caused by the wreck, or instead were more due to decades of manual labor that had led to a lot of bone spurs, etc. About a week before the deposition, completely unexpected info fell into my lap from several states away, and I knew exactly what my first question for the doctor was going to be on cross-examination. Plaintiff's attorney went through his questions. Then it was my turn. Dr. So-and-so, did you plead guilty to conspiracy to commit healthcare fraud 10 days ago in federal court in Texas? Of course he said yes. And I then went through and got his acknowledgement as to all the details of what he had been participating in. As part of any plea deal in federal court, you have to be completely open and forthcoming about everything involved in the crime you plead guilty to. Otherwise, the plea can be rescinded. Other attorney played it cool, but had absolutely no idea about either the criminal charges or the guilty plea, and was extremely mad at the doctor, who was someone they seemed to refer a lot of clients to. Soon after, plaintiff offered to settle for the last offer we had made at mediation. Story 55. I was with witnesses and counsel. Ahead of an appeal hearing, appellant was overseas. Whilst preparing the witnesses beforehand, 5 mans before the hearing is due to start, it transpires that the witnesses lied in their witness statements about a fairly large credibility point. Counsel and I cannot mislead the court, and so we threatened to walk out unless they agreed to amend their statements before the judge. They agreed, but were clearly terrified they had fatally undermined the appeal, which they would have if the other side had actually showed up to court. Long story short, we amended the statements, and because the other side couldn't be bothered to send anyone to represent themselves and question the credibility of the witnesses, the judge wasn't particularly bothered by the change. We proceeded to win the appeal, hooray, and they all had lemonade the end. Story 56. Of all things, this started with an eviction. I'm retained by the mother of the named tenant, as he was recently hospitalized and not responsive. I was presented with a power of attorney for mom to act for the incapacitated party, followed by the following documents. 1. The eviction claim saying the rental home was to be destroyed for substantial structural defects in the foundation. Attached was the city order for defect and a stamped engineer's inspection report. Then I hear, but you don't understand. They have a rent-to-own agreement and have for 3 years. Then I get 2, a signed agreement of purchase and sales with a 7% down payment and a receipt matching that amount. 3, an estimate for repair to the structural damage with receipt for payment. 4, a photocopy of an engineer's report showing a clean inspection post-repair. The client rep says there are clearly jurisdiction questions, and we've spelled them out in this statement of claim. 5, an original court-issued stamped copy of a $300K superior court claim with an injunction paper clipped like a cover page. I show up to court, but no client or rep. I ask leave for a motion for jurisdiction with the above documents in hand. What I would have loved to know sooner was that this wasn't the first appearance, but the 4th. There were orders for the client and rep to appear, as they had failed 3 times prior. Also, that every document I was given to help the client, with 2 exceptions, were complete and 100% verifiable forgeries. First was the receipt they called a down payment. It was in fact for 1 year's rent. The second was the superior court claim. The father of the incapacitated tenant, for bonus points, it was rehab, filed his own fabricated documents to support the claim while the kid was away. Needless to say, judges make their displeasure known when people piss on their robes. Haha, TLDR. I wish I knew sooner the client was in rehab. They had found a new counsel every time they had an order for failure to appear, and that 275-ish pages of bound copies of evidence for service were in fact forgeries. Things that could have been brought to my attention yesterday. Story 57. Employment lawyer here. I mostly represent companies. This happens a lot, but to be honest, it usually isn't the client's fault when the client is a company. For example, we had a big sex discrimination claim we were defending. At one point, we uncovered an email sent from one colleague to another that was smoking gun stuff. The problem is, both those employees had left the company a few months ago. The first time we knew of their sexist banter was months down the line in the thick of discovery disclosure. We settled soon after. Story 58. More of an issue of me being a child than accidentally withholding information. When I was younger, my mom and my dad were having a custody battle over me. Normal stuff. My mom was a heavy drug addict. She was good at hiding it though, at least to my 10-year-old self. She would routinely wake me up at about 10 or 11 p.m. to take me on a car trip because I loved being in the car and playing my Nintendo Ds. We would drive to a specific place that was about an hour away, then come back after meeting with her friend. We'll call him Tim. I hated Tim. He always scared me, even though he tried to be friendly. He never actually did anything, just a scary dude. I got bad vibes from him. As it turns out, he was her drug dealer. We went on these trips for about 2 years, so I would be about 12 when I finally told my dad that I hated Tim. I hated that he kept moving around in shady areas that made me feel scared. It didn't take me too long after that to realize he was her drug dealer. I thought it was just weed, but it was more. The fact that my mother took me on drug deals as a 10, 12-year-old was the final nail in her coffin, and my dad finally got full custody of me later that year. Story 59. from when I was a case officer for my country's migration agency. I used to conduct investigations and interviews of asylum seekers as part of the asylum process. Seekers had to answer questions about who they are and why they are in need of asylum. One person, let's say Kim, since Kim can be both male and female, applied for asylum. Kim had a somewhat thought-through story about why Kim needed protection. The story included events through Kim's life since a young age, and also that Kim had never left Kim's home country. Leaving your home country and voluntarily returning is usually a sign that you're not that much in need of protection. This person had a notice to her name that said that Kim had applied for a visa to another European country, from a country that was not Kim's home country. This may be explained in many ways, for example, by saying that Kim never returned to Kim's home country. I asked about this, and the conversation went as follows. Me: I wish to confirm. You said that you never left your home country before DDEM 2015, correct? Kim: yes. Me: I see here that you applied for a visa to X from Z in 2013. What's this about? Kim: No, that was a friend. I gave him my passport. Me: so you've never been in country Z? Kim: no. Me: but Kim, the reason I ask is that my system tells me that your fingerprint was used in an application in country Z for a visa. Kim: oh, me. This was years before you tell me that you started your journey to Europe. What's your take on this information? Kim's lawyer put his hand to his face. Kim did not have an explanation. Kim did not get the benefit of doubt. Edit, spelling was on my phone earlier. Story 60. Had a client who was a single mother, and both her and baby daddy had lost custody of kid. I decide that I want to raise hell in court and demand that father take a drug test. I believed father was using heavily, and that him failing would set him back and favor mother. I knew this meant Mom would also have to take a drug test, so I wanted to be sure she could pass. We prepped for court for an hour, and I'd stop every 5 minutes to ask her if she could pass a drug test. Told her my strategy, told her that if she couldn't, that it would be fine, and we just wouldn't ask for one, and we'd likely not have to take one at all. Every time she denied drug use. Every single time. We go into court. I raise hell for a drug test. Both are ordered to take one. He fails for marijuana. She lights up that drug test for just about everything, including meth. She was 8+ months pregnant. Story 61. Client hurt his back at work and claimed it hurt too much to drive long distances. We get the opposing side to put him in a work hardening program in a city 40 miles away and pay for a hotel there so he can do treatment. We get a deposition notice, and the opposing counsel sends their surveillance footage along with it. Client is caught on video driving home 40 miles to pick up his GF, and kid then driving another 50 miles across state lines. He makes one stop, and it is to a pot store. He is on video leaving the pot store with a bag in his hand and driving the 90 miles back. Attorney was mad. He worked hard to get the OC to provide all these accommodations because his back hurt too much to drive. Amazing attorney, though. During the deposition, he shut down the other attorney when questioning the client about the bag he got from the pot store, as it was circumstantial, and he couldn't prove what he bought there or what was in the bag, and how client missed his family since he did the program during the week. So he bore the pain to be able to see them. Story 62. A lady applied to be a legal assistant at my firm. She casually mentioned that she knew me and some clients I had. My boss ran it by me. When he said her name, I told him yes, I indeed knew who this lady was. My clients were the ones applying for custody of her kids to get them away from her. Her file with Child Family Services was as thick as a tome. Application declined. Story 63. I am a divorce lawyer, and this happened to the senior lawyer I work for. She goes into a motion that the father brought where he was seeking interim custody of the young child. Client had told my boss that she was a restaurant server and worked for cash. Okay, on the day of the motion, she sees that the other lawyer is in a suspiciously good mood. He comes up to her with a box full of photos and documents that prove that our client is a stripper and a prostitute, like she even has an adult entertainment license from the city, because this is regulated, de facto legalized over here. Anyways, my boss says to the client, "Why didn't you tell me that you're a stripper prostitute?" Client: I didn't think it was important. The judge granted the father's motion and gave him interim custody. The judge said that the nature of the mother's employment meant that she would work late hours well into the night, meaning that there would be no one to care for the young child. If she had told us sooner, we could have done something about it, like propose a schedule whereby family and friends cared for the child while she worked, but she hid it from us. Story 64. Had a client accused of hitting his female roommate on the back with an object Doesn't matter what it was. He confessed to the police that he had done it. Very remorseful and tearful. Non-English speaker. Told me, be understood, that he had committed assault and was ready to take his punishment. I asked him why he hit the roommate with the object. He said, because of my wife. I asked what he meant, and he explained that the roommate was on top of his pregnant wife, attempting to choke her when my client hit the roommate. Nobody had bothered to ask anyone involved. The roommate simply told the police that my client hit them, and my client agreed that he'd hit them. Story 65. I worked on a motion for summary judgment for a client in a small town for months. I put hundreds of hours into this thing. It was meticulously supported by both the law and undisputed facts. I had depositions and affidavits that made it clear that summary judgment should be granted in my client's favor. I submit it, and months later, I'm in front of the judge to argue the motion. His Honor holds the motion up in the air. Using both hands, it was huge, drops it in front of him and says, "Counsel, what is this?" Shocked, I reply, "Your Honor, it's our motion for summary judgment and all the supporting evidence." He says, "I didn't read it, and I'm not going to read it. This is going to trial." Gavel banged. I turn to my client and give him a WTF just happened? Look, and he says, "I knew that idiot wouldn't give us a fair trial. He's hated me ever since our business fell apart." Apparently, a partnership between the judge and my client had soured years earlier, likely because my client stole from the judge, and at no point in any of the many meetings we had concerning the case did my client think to mention this, nor did he bring it up when I asked him if there was any reason that the judge might be biased and if we should file a motion for a new judge. Story 66. Had a client accused of DUI. According to her, she never drove the car. Someone else did. I won the case for her in district courts. The prosecution could not prove she drove the car. During appeal, not my case anymore, different lawyer, she took the stand again. On a side question regarding behavior of the car, she explained in full details how the steering wheel felt as she drove down a specific road. She then explained to the court how she was not driving when they were stopped by the police. There was a quick guilty verdict. Story 67. Retained client theft case. One thing I always do is make sure the client reads the information, which is the document officially charging the defendant with a crime. It alleges a specific date of the offense. Prosecutors claim to have him on video. Damned if it didn't look a lot like him. We go through the whole 9 yards of motions, hearings, trial settings, about 9 months of bullshit and thousands of dollars. Right before we are set to pick a jury, he starts muttering, "This is such bullshit, something jail." I stopped and asked him, WTF, he just said. He confirmed my suspicion by telling me for the first time ever that he was in jail in another county on an unrelated charge for about 4 days, during which the alleged theft happened. 20 minutes and a phone call by the prosecutor to the other county sheriff, and they faxed a magistrate log confirming it. Immediate dismissal. Idiot wasted 9 months and thousands of dollars because he was embarrassed by the prior arrest. Story 68. Defense attorney at a military administrative separation hearing. Client's roommates, co-workers reported they found marijuana in his room. A lot of bad facts for my guy, like a lot. But the investigation was very thin, and we had one good fact. He had never popped on numerous tests, including ones that he should have popped on given the roommate's story. I am cross-examining one of the roommates, showing that they really disliked this guy and wanted him gone. It went about as well as I could hope. Now, the number one rule of cross-examination is never ask a question you don't know the answer to. I'm wrapping up and lean over and ask the client if there's anything else I should ask. He says, "Why? If I was using marijuana, did the tests all come back negative?" I thought, sure, bring it back to our good fact. Forgetting the first rule, I asked. She said, "Oh, I overheard him talking to our pot-smoking neighbors, how he wasn't worried because he had bought a thing to spoof the tests." Given the rest of his character evidence, this was absolutely more plausible than the wishful alternative, but it was the first evidence that directly suggested he was cheating the tests. My one good fact was now just another bad fact. Moral of the story: if you are cross-examining a witness, only ask questions you know the answer to. Story 69. I once had a client in a child custody mediation where I represented the woman and her ex-boyfriend was on the other side. We were trying to agree on custody and child support for their one child they had together. We get nowhere for about 4 hours until the mediator says he found something out from the other side and that my client needed to tell me something. Turns out she was currently pregnant, not with her current boyfriend's child, but with her ex-boyfriend's child that we were currently mediating with. Hard to strike a negotiation when I don't know there's a second child to be. Told her if she ever lied to me again, I'd fire her. Story 70. It fortunately wasn't my client, but at a child custody mediation, once our point of emphasis was Dad's drinking problems. Dad and his attorney make all kinds of noises about how he's sober, going to AA, providing a safe home, etc. I have never felt more like Matlock than when I ran his name in the court's website and found a DUI from the week before with his toddler child in the vehicle. His mom had picked the kid up and never told the child's mother. Screenshotted it, emailed it to the mediator and attorney in the other room. Another attorney came in 5 minutes later, white as a sheet. We settled within 30 minutes. Story 71. This was a civil suit for nuisance between two neighbors, with a trial date already set when the client approached me. My client was accused, amongst other things, of urinating on his neighbor's front door, throwing cartons of stale milk at his neighbor's window, throwing paint over the back garden. I was thinking nobody in their right mind would do any of this schmidt, so I need to help this man. He explained there was a history between them and the neighbor was still aggrieved about a failed planning application that my man successfully objected to. So I get a copy of all the papers, and nothing untoward is contained in them. So we go to a case management hearing to make sure everything is ready for the tail. At that time, the other side says to the court that video facilities will be required for the court to view the CCTV footage of my client doing all the acts he was accused of. That was within my first year of practice and was a very valuable lesson. Story 72. Doing an eviction defense case. Landlord refused to accept rent, which is illegal in my state. Turns out landlord refused to accept rent, caused tenant broke into adjoining unit and set fire to it, because she was fighting with her neighbor. Never mentioned it. And I filed exceptions for the refusal to accept. So I walked in, after calling the case, immediately launched into my argument how this was improper. Now, it still legally was incorrect, but an eviction for non-payment is way more advisable than an eviction for cause. I nearly just walked out of the courtroom. Would have been better for my client. Story 73. Defending a client against a complaint of racial discrimination from a contractor. Matter proceeds through all preliminaries, disclosure, and heads for trial. In passing 2 weeks before trial, client mentions that he and the contractor were sleeping together for several years and stopped around 2 months before the complaint. Story 74. This will sound bad, but she should have told me she was pregnant. Client beat the crap out of her baby daddy's car at a stoplight with a tire iron. Was arrested. Video evidence was irrefutable. She went to jail, multiple priors, and was on probation. I went to see her in jail and put some money in her commissary since she needed a toothbrush. She mentioned offhand that baby daddy was in jail and good riddance since he got her pregnant again. Holla, you're pregnant? How far along? Damn, woman. I could have played up the compassionate side of the judge to avoid jail time. She told me it was all good. She could do a month easy, then get released early and avoid probation, which actually makes a lot of sense. Wished her good luck. Story 75. Had to help a man obtain asylum in my country because he was being wrongfully threatened by other families back home. During asylum interview, I explained he had a blank criminal record, and he was a model citizen. Apparently, the interviewers found out the guy was a convicted murderer in 2 countries and a war criminal. Asylum was denied. Story 76, client charged with sex with minor. It was his word versus hers, so prosecutor did not have an airtight case. I was able to negotiate him a sweet deal, keeping him out of prison, but at the urging of his wife, he declined and insisted he was innocent. When he was arrested, they did a search warrant on his computer and cameras. Initially, nothing was found. As case progressed, they found a SD card that had not been sent to forensics. Lo and behold, it was full of incriminating photos of client and minor in very compromising positions. Sweet deal went off the table, and he went to prison instead. Story 77. My uncle is an attorney, and when he was starting out, he was working in an office under another attorney gathering documents, information and filing paperwork mostly. One morning, a prospective client showed up in person, asking to speak to a lawyer about their case. It was basically fighting an expensive traffic tickets, but they were essentially going to lose their license over it if convicted. To make things more complicated, the married cop that wrote the ticket was banging the client's sister on the side, and she confronted the wife previous to the traffic stop. Accusations of retaliation flew, and my uncle thought they actually had a decent case to fight the ticket. Why, yes. He asked the guy when his court date was, to which he responded, 3/15. Uncle says, no, what date? And the guy says, today. Story 78. I had a pro bono divorce client fail to tell me before her deposition that she had been sleeping with a married doctor at her place of employment during the divorce, which plays into alimony issues and is therefore relevant. Of course, she got asked about it in the deposition, when she stormed out of the room and I informed her that there wasn't much we could do without her risking sanction, and I wished she had told me during any of the many times I'd asked her if there was anything I needed to know. She stormed back into the deposition room and announced that she was firing me. It's the only time I've ever been fired. I've stayed on the service list, and I think 5 or 6 attorneys have withdrawn since. Their divorce, which involves very few assets, has also been pending for 3 or 4 years now without resolution. Story 79. I had a refugee citizenship case, asylum case, and the client claimed to be underage. He only had a birth certificate, but no other documents, which is really common because travel agents, sheer smugglers, take them away from you. His birth certificate showed him being underage, but the Eind Dutch immigration agency didn't accept the certificate from his country of origin because it was often fake. So we were stuck because we couldn't get documents from the government because his country of origin was so corrupt that their embassy recently was kicked out of the country. I tried a lot of times, even called up organizations throughout the country in the hope they had contacts in the government. His asylum request was denied. He went into the illegality, and I still tried to gather evidence for a renewed asylum request, HASA. After 2 months of me trying, he told me he was actually 23, dropped all my activities instantly. Story 80. I had a client who chased her teenage son around the kitchen with a broom. She was from out of state, and I just had this feeling she was not telling me everything, and I asked her several different times if there was anything I should know, to which she replied no each time. We were doing an unagreed plea bargain, and when it was her turn, the prosecutor opposed the plea, stating that my client has been convicted of manslaughter several years ago in another state. That courtroom came to a dead stop, and all eyes were on my client for a very long moment. I gathered myself and said, for which she served her time and paid her debt to society, Your Honor. The judge actually accepted the plea, but for sure that was a perhaps you should have told me that moment.